Hi, my name is Decius, and this presentation is called How the Second Amendment Works. I am a person who believes that what's great about the United States, why I like being an American citizen, is that this is a free country. And the reason that this is a free country is because we respect people's individual rights. And I've spent a lot of time trying to understand what that means in detail because I think that our our individual rights are often threatened. They're threatened because they interfere with things that social forces want to accomplish. They're also threatened because technological change creates new circumstances, and it's not always clear, how our rights should apply in those circumstances. To me, one of the most challenging parts of the Constitution is the Second Amendment. It's obviously one of the most controversial parts of the Constitution, and I've always struggled with it personally. The text of the amendment seems pretty unambiguous. It says, "The right of the people to keep and bear arms shall not be infringed." I mean, that's pretty clear. Uh, what does that mean? Does that mean that I have a right to have machine guns and surface-to-air missiles at my house? Can I have a nuclear weapon? They wouldn't let Saddam Hussein have a nuclear weapon, and he ran a whole country. That just doesn't seem, maybe that's what the text means, but it just doesn't seem like it's something that's practical that we could actually do in our society. Um, is the government just sort of flagrantly ignoring the text of the Constitution when they, enact gun control policies? These are questions that I've asked throughout my life, and I've gotten answers that I never found to be totally satisfactory. I looked at this old Supreme Court precedent, Miller, and it talks specifically about sawed-off shotguns, and it does not really address the overarching question for me. And so, a few years ago, I was doing some reading. And I kind of haven't had an epiphany about this. I think that I reached a realization of how this was originally supposed to work and why it doesn't work that way anymore. And the reason might be surprising to you. It's not a consequence of technological change. It's really because the Constitution has been amended. So I'm gonna talk about that, and that's really what this talk is about. I think that. If we're going to look at this subject, we need to start by giving it a certain amount of respect. People tend to get very emotional in their opinions about this topic because they see, their rights at stake. They see their safety at stake. And I think people have a very hard time understanding why other people, might approach the issue from a completely different point of view. And so you end up, because you don't understand why someone disagrees with you, you end up assuming that they're stupid or they have some sort of ulterior motive. And the reality is that everybody needs to just take a step back and take a deep breath and understand that the reality is that we come at this issue from different perspectives because the issue is ambiguous. It really is. The different sort of polarized views that we're familiar with today regarding the Second Amendment were discussed in or set out in Supreme Court decisions of different states way back in the 1840s. And so, Americans have not seen eye to eye about these issues for a very long time. And the fact is that if you want to, come up with a bunch of facts from the historical record that support your point of view, whatever it is, there are ample facts out there that will support your point of view, regardless of what side of the fence you're on. And this is kind of how partisan pundits lie. The way that they lie is they take a situation, a set of facts, and they go through that set of facts and they select the facts that align to the conclusion that they're interested in. And then they tell a story where they emphasize those specific facts that support their conclusion. And they either don't tell you about the other facts, or they rationalize them away, or they de-emphasize them. And so when you read their positions, or you hear their positions, you hear somebody who gives you a bunch of information that's true, and all that information seems to support the conclusion they've reached, and then they tell you what their conclusion is, and it's difficult to attack because nothing they're telling you isn't true. The problem is that there's a whole lot of stuff that they aren't giving you. They're not giving you a full picture. And unfortunately, I think that most people who write about the Second Amendment are partisan pundits, and they don't objectively look at all of the facts. And I say that not just in the context of people who write articles about this subject. I mean, the academic law professors, the historians, the Supreme Court justices that write about this subject, they all seem to lack a capability to look objectively at this issue and to treat all of the facts fairly. And I think that honestly, these professionals have done the American people a disservice because they have failed to provide us with a clear understanding of what our Constitution means that we can all agree with. Mostly because they're unwilling to set their self-interest aside and let the facts speak for themselves. But I ask that if you're listening to this talk, that you set your self-interest aside. The reality is that the Constitution means what it means, regardless of whether or not it fits with your personal policy preferences. It's okay for you to disagree with it. It's okay for you to want to change it. But what it means is not subject to your opinion, and you should look at the meaning as from an objective point of view, and then ask, what you need to do as a consequence. So this is a quote that I got from the front of a law review article about the Fourth Amendment that I read once, and I think that it comes from a novel, and I think that it does a good job of explaining something, and that is that the way that people who lived 200 years ago thought about the Constitution is different from the way that we think about it now. The past is a foreign country. They do things differently there. I think that this is a good thing to keep in mind when we're trying to interpret things from the perspective of people who lived several hundred years ago. Some of the questions that we struggle with today, the past doesn't answer, the historical record doesn't address, because the people who lived in that time never encountered the circumstances that we face that caused them to ask those questions. And so, people tend to make assumptions one way or the other about what people in the past would have thought about the circumstances that we're considering. And I think that they do so sometimes from our perspective instead of from theirs. The fact is that the way that that we read the Constitution today it's important, it's valid. The Constitution ought to be meaningful to common people who read it today. And generally speaking, it is. But the way that people in the past read it was different, primarily as a consequence of the fact that the Constitution has been amended many times since it was first written. The most important of these amendments occurred as a consequence of the American Civil War. After the Civil War was over, there were a group of people in Congress who could be categorized, or they're called the Radical Republicans, and what they tried to do was protect the civil liberties of both the recently freed slaves as well as other people who might be victims of the former Confederacy, including Unionists who lived in the South, Northerners who traveled down there. They wanted to ensure that all of these people's civil liberties were protected. And so they passed the 14th Amendment, which is the most important amendment in the Constitution. And I think that, really our high school civics classes kind of oversimplify the discussion too much. I think that people underestimate the significant impact that the Civil War and the amendments that happened after it have on the nature of the Constitution and the way that it should be read. When the Constitution was written, the amendments that were tacked to it were supposed to be limits on the Constitution as opposed to spheres of our individual rights. The First Amendment, for example, prohibited the Congress from regulating speech or the press, but it didn't say anything about state governments. It didn't say anything about local governments. And state and local governments could do those things without interference from the federal government. The Bill of Rights was really a constraint on the federal government. It was not a constraint on the states. It was not a constraint on local governments. And that's what the 14th Amendment changed. It really changed us from this federal society to a society where we all have specific individual rights that are protected by our Constitution, the way we think about it today. It's important to understand the way that change affects the way that we read constitutional amendments. So just to give you some examples of what I'm talking about, the Constitution of South Carolina, which was written in 1778, says that the Christian Protestant religion is the established religion of this state. Now, I'm sure most of you listening know that the First Amendment, prohibits an establishment of religion. This is specifically prohibited. So what's important to understand is, like I said, the First Amendment only applied to the federal government. It didn't apply to the states. It did not prohibit South Carolina from having an establishment of religion. James Madison, when he proposed the amendments that became the Bill of Rights, he actually included a specific amendment with constraints upon the power of state governments. And this is it. It says, no state shall violate the equal rights of conscience, which what he means is that South Carolina can't have an establishment of religion, or the freedom of the press, or trial by jury in criminal cases. Those are, specific constraints that he thought that states should have to uphold as well as the federal government. It's important to understand that this wasn't passed. You may never have seen this text before. It was not included as one of the Bill of Rights that we are ultimately are part of our Constitution. And so Congress made a deliberate decision not to constrain the states in these ways. So when we read the First Amendment, again, it says Congress shall make no law respecting an establishment of religion. It doesn't say your local state government. It doesn't say, so the reality is that if the police, show up and arrest you and start searching your stuff, you're going to argue that they're violating your Fourth Amendment rights, perhaps if they don't have a warrant. And the reality is that originally the Fourth Amendment was only a constraint upon the federal government, and because the local police don't work for the federal government, that claim wouldn't make any sense. The only reason that claim makes sense, the only reason you can raise the Fourth Amendment as an issue vis-a-vis your local government is because of the 14th Amendment, because the 14th Amendment requires your state to respect your privileges and immunities and your due process as a citizen of the United States. So that's the first fact I need you to understand as we go into this discussion, that the way that we read the Constitution when it was first created is different from the way that we read it now. The things like the right to freedom of speech have slowly become more and more expansive in their interpretation over time. The second thing is that we need to understand the context in which the Second Amendment was passed. So this is the text of the English Bill of Rights, which was passed in 1689 after the English Civil War, a conflict between Catholics and Protestants, and there was a lot of concern because King James II, who was Catholic, had created a standing army of papists. And he had disarmed Protestant subjects And the Parliament, once it regained control of the country, sought to reestablish rights which were considered traditional rights of Englishmen. And so one of the things they said is that the king was not allowed to keep a standing army in a time of peace unless they had consent of Parliament. And secondly, the Protestants, meaning in addition to Catholics, may have arms for their defense suitable to their conditions and as allowed by law. In other words, the disarming of the Protestants was not lawful. So this really represents what is considered to be an ancient right within English common law, that people have the right to have arms for their defense, for their self-defense, and potentially for participation in a militia. But it's also caveated in two ways. The first way it's caveated is suitable to their condition. So what that means is that there's a class hierarchy in place in England in the 1600s. And if you're an elite Englishman, you have a more expansive right to bear arms than if you're a commoner. It also, as allowed by law, basically, this is a right that's set against the king. The Parliament still has the power to regulate the personal possession of arms. So they're saying that people have a right to bear arms, but that right can be regulated by the government. So this is from the United States Constitution. This is the part that empowers Congress to create a military. And also to operate the militia. So you can see that the Congress has the power to create an army, create a navy. They can regulate them. In addition, they have the power to call forth the militia. They provide for organizing, arming, and disciplining of the militia, and for governing them. Part of them is maybe employed in service to the United States. So. The federal government not only can have a standing army, but they have a lot of control over the state militias as well. And this is something that a lot of people living in the founding time, were afraid of. They were afraid that the federal government would have too much power with the standing army, that because they had the responsibility for organizing and arming and disciplining the militia, that they might be able to underplay that or do that poorly or underfund that in a way that usurped the militia's power. So there was a real concern about this. And Madison discusses that concern in Federalist 46. Federalist 46 is a document that a lot of individual rights advocates who are interested in that perspective of the Second Amendment, point to, because it says that the American people are armed, and so they point this out and they say, see, it says we're armed. Besides the advantage of being armed, which Americans possess over other people of almost every other nation, and it goes on. So yes, it does say that, it does acknowledge that individuals are armed, but it also says that that's not sufficient to protect the people's liberty. The fact that they have weapons is not enough, and that's a very important point. Basically, the people in the time of the founding did not believe that a militia was effective unless it was well regulated, meaning trained. And so the point of Federalist 46 is he's saying that the fact that you have guns is not enough. You have to be trained, and it's very important that we organize that training effectively, and that's why Congress has been given the power to do it. But you needn't worry that Congress has too much power, because the officers of the state militia will be chosen by the state governments. And so the state government, which you have also duly elected, chooses the people who are the commanders of this state militia. And those people are not going to lead that state militia into a use that the people of that state oppose, basically. So the Madison was very conscious of the federal structure of the system that he was constructing. And I think that he really felt that creating these kind of hybrid systems where there's power over here and power over there, and people have to work together in order to do things, that's how you prevented tyranny. It's systems of checks and balances. So you can see that here in the structure of the militia. The state governments choose the officers. The federal government provides arms and training. And the reality is that neither of them has too much power. They're set against each other. So with that in mind, consider this amendment: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I think that what Madison was attempting to do here is he was attempting to, first of all, he's saying to the states that a well-regulated militia is necessary to the security of a free state. It's to a certain extent, everyone's responsibility to ensure that a militia exists and that it is well regulated, it is well trained, and to that end, I think that Madison intended to get the federal government entirely out of the business of regulating arms. I think that the right of the people to keep and bear arms shall not be infringed text means that the federal government was completely prohibited from dabbling in that sort of regulation. But understand that Madison wrote this with the knowledge that these amendments that were part of the Constitution did not constrain the power of state governments. He knew that the state governments had the power to regulate people's possession of arms. So the reality is that even though the federal government was out of that business, that the states would still have that authority. And that's the sort of system that Madison originally envisioned. And even if you look at that amendment that I showed you that was proposed that specifically was designed to constrain the power of states, nothing about the right to bear arms was listed in that section. It referred to freedom of religion, freedom of the press, and the right to trial by jury. So, I think that's how this was supposed to work. It's important to understand that the Constitution was subsequently amended, and so it doesn't work this way anymore. But I think it's worth taking a look at the world of before the Civil War on the state level and see what the states were doing, what rules they were enforcing. So Madison actually proposed a bill in the Virginia legislature that had to do with regulating hunting. And if you had been busted for hunting deer illegally, one of the punishments that you could be sort of given is that you would be prohibited from bearing a gun out of your enclosed ground unless whilst performing military duty. The reason I bring this up, and people frequently bring this up as an example of the fact that Madison must have believed that states had the power to constrain the individual use of arms or carrying of arms in specific contexts, perhaps accepting in the context of military service. Thomas Jefferson proposed that the Virginia Constitution carve out an individual right to bear arms. He said, "No freeman shall be debarred the use of arms within his own lands and tenements." Which it seems reasonable, however, it's interesting that Thomas Jefferson felt this way, that you had an individual right to use arms within your own land, but Virginia did not actually end up including this text in their constitution. So it's a viewpoint that was there at that period of time from a person we all have a lot of respect for, but it wasn't the law. The Virginia legislature could have debarred people from the use of arms on their own lands, and specifically chose to retain that power. Here's the constitutional or the statement from the Virginia Constitution, regarding the militia, and there's no text in this statement that has to do with the individual right to bear arms or the right to keep and bear arms. There was some text added to this in the 1970s that is similar to what's in the U.S. Constitution, but for 200 years, this is what the Virginia Constitution has said. There are other constitutions of states that are worth looking at. In the beginning, only a handful of states actually talked about militias or the right to bear arms in their constitution. North Carolina is one of them. And here they say the people have a right to bear arms for defense of the state. And so, that seems pretty narrow. It's not a broad individual right to bear arms. And I'll come back to that in a minute. What's interesting is we can read the text of these amendments, but then they end up getting interpreted by the various state Supreme Courts, and the interpretations are kind of all over the map. And I'll talk about that shortly. So on the other hand, the Pennsylvania Declaration of Rights also mentioned the right to bear arms, and their text seems to be, more specifically delineating an individual right, that the people have a right to bear arms for the defense of themselves and the state, and not just for the defense of the state. So you can see that there's different kinds of views here. Justice Stevens argued that Madison, had access to a lot of different potential formulations for the Second Amendment when, he went into, writing the Bill of Rights, and that he might have, that he intentionally chose a formulation that did not specifically refer to individuals. And that's interesting, but at the same time, I would argue that the Constitution was not a constraint upon the power of the states, and so it didn't even really matter that the individual was not mentioned there. It was really the state constitutions that protected individual rights at that time, and so that might be why Madison decided, not to include a specific reference to individuals. So Pennsylvania ultimately decided to amend their constitution, and they said, that the right of citizens to bear arms in defense of themselves and the state shall not be questioned. Okay, dude. I'm glad I'm not giving this presentation in Pennsylvania or Kentucky. Over time, there are a number of states that did pass Second Amendment equivalents that did seem to have more of an individual right that they protected. In Mississippi, every citizen has a right to bear arms in defense of himself in the state. Himself is more specifically an individual right than themselves. Every citizen has a right to bear arms in defense of himself in the state. Connecticut, 1818, Alabama, 1819, Michigan, 1835, Texas, 1836. Now, the thing that's strange is that there are states on this list whose courts allowed for constraints on things like concealed carry, and then that's North Carolina's court eventually interpreted this as their amendment as being incorporating an individual right, and so these textual differences, it's important to understand, were interpreted in different ways by different courts. And really what I'm getting to is that there was a great deal of confusion at the state court level about what all of these things meant, particularly by 1840, although the controversies began really as early as 1820. So let me give you this example. This is Nunn versus Georgia. Georgia did not have anything in their state constitution about the right to bear arms. And they passed a law, I think, prohibiting concealed carry, and the law was overturned, and the court wrote, "The right of the whole people, old and young, men, women, and boys, and not the militia only, to keep and bear arms of every description, not such merely as used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree." And all this for the important end to be attained, the rearing up and qualifying of a well-regulated militia, so vitally necessary to the security of a free state. Our opinion is that any law, state or federal, is repugnant to the Constitution and void, which contravenes this right, originally belonging to our forefathers, trampled underfoot by Charles I and his two wicked sons and successors, reestablished by the Revolution of 1688, conveyed to this land of liberty by the colonists, and finally incorporated conspicuously into our own Magna Charta. Quite a rant. Now, um, people who support a collective rights interpretation of the Constitution, are quick to attack this ruling on several grounds. This ruling is obviously saying that the state of Georgia has to respect the Second Amendment. But as I've explained, the Second Amendment or any of the Bill of Rights did not apply to Georgia in the 1840s, and in fact, in the 1830s, the Supreme Court of the federal government had said as much. Furthermore, as I showed you before, the right to bear arms that was defended in traditional, English common law was not as broad as it's represented here. And so, there are a lot of reasons to criticize this decision, but at the same time, I think it's important to understand that there were people who lived in the 1840s who had this view, and not just any people. This is the Supreme Court of a state. And so clearly, the broad individual rights view that we see today in the minds of some people, this is a view that has been around for a long time. Here's another example. It's Arkansas versus Buzzard in 1842. The words "a well-regulated militia being necessary for the security of a free state" and the words "common defense" clearly show the true intent and meaning of these constitutions and prove that it is a political and not an individual right, and of course that the state, in her legislative capacity, has the right to regulate and control it. So Arkansas versus Buzzard reached what we would now call a collectivist or civic version of the Second Amendment, which is that the Second Amendment protects a right to bear arms in the service of a militia, and it doesn't protect an individual right to bear arms for self-defense or other purposes. This is the other sort of side of the spectrum, again being represented by a Supreme Court of a state in the 1840s. So it's clear that by 1846. Both polarized views that we have today of this issue, had been expressed by state Supreme Courts. So I want to show you another court decision. It's a particularly important one. It's Aymette versus Tennessee in 1840. Now, back in 1840, Tennessee was the frontier, and a lot of people there were tough people. And, there were a lot of issues with brawls happening in bars, and people tended to come to those bars, heavily armed. And so there was a law that Tennessee passed, prohibited anyone from wearing a Bowie knife or Arkansas toothpick or other knife or weapon in any form, shape, or size resembling a Bowie knife or Arkansas toothpick under his clothes or concealed about his person, right? Concealed carry. And someone challenged it on constitutional grounds. They said that it violated their, Tennessee's equivalent of the right to keep and bear arms. And so, in Aymette, the Tennessee Supreme Court disagreed. They said that rule was lawful, and they drew this interesting distinction. They said that the right to keep and bear arms applies specifically to the kinds of weapons that are used in civilized warfare, and that you have a right to these weapons, but the legislature can regulate the manner in which they may be employed. Furthermore, there are certain weapons which have nothing to do with civilized warfare, and the legislature has the power to prohibit those entirely. So I think this is interesting because it's kind of a middle ground. They are saying that you have an individual right to possess certain weapons, but not all weapons, and you don't get to use them in all circumstances, or at least the legislature has the power to regulate their use. And so the reason that this decision is important is because it was relied on heavily by the court in Miller, which I'll show you later. Miller was in 1933. And in fact, I think that to a certain extent, Heller continues the line of reasoning that began here. And even though they attacked this case, the ultimate conclusion or holding of this case is upheld in Miller, and so I'll get there. But what's important is that a lot changed as a consequence of the Civil War. After the Civil War occurred, this engraving represents a problem that people were concerned about, where mobs of angry, white former Confederate soldiers were, attacking groups of freedmen and there was a real problem with lynchings and the like. And so there was a real concern that the rights of freedmen needed to be protected, and their physical security needed to be protected. This engraving is interesting to me because in the picture you can see both a Bowie knife in the top left hand corner and an Arkansas toothpick, which is right under the gentleman in the middle. It's right under his arm there. So you can see the kinds of weapons that were employed at the time. Also, there's a number of individuals in the picture with muskets and clubs. Um, so when the radical Republicans in Congress set about to adopting the 14th Amendment, they intended to require the states to respect a variety of different individual rights of not just yes, of the freedmen, but not just of the freedmen, but of everyone. And I think it's really important that as American citizens we understand that our individual rights were constitutionally protected as a consequence of the 14th Amendment, and that's something that applies to all of us. But I have a few historical references that specifically discuss the right to bear arms and whether the right to bear arms was one of those rights that the radical Republicans intended to force the states to respect. And in fact, I think there is a lot of evidence to suggest that it was. So this is Clarence Thomas quoting Frederick Douglass. And I would have quoted Frederick Douglass directly, but I couldn't find this reference online. It says, as Frederick Douglass explained, the legislatures of the South can take from him the right to keep and bear arms as they can. They would not allow a Negro to walk with a cane where I came from. They would not allow 5 of them to assemble together. Notwithstanding the provision of the Constitution of the United States that the right to keep and bear arms shall not be abridged, Douglass explained that the black man has never had the right to keep and bear arms. Absent a constitutional amendment to enforce that right against the states, he insisted that the work of the abolitionists was not finished. So I think this is interesting, both because clearly Frederick Douglass, living in the 1860s, obviously also before and after, felt that the Second Amendment seemed to apply to an individual right, and he also felt that that right needed to apply to freedmen as well as white citizens. This opinion that I'm quoting here by Clarence Thomas in McDonald versus Chicago is actually my favorite. I've read a lot of Supreme Court opinions about the Second Amendment in assembling this material. It is my favorite opinion for a reason that's very arcane, having to do with interpretation of the 14th Amendment. I don't really have time to go into those details within the context of this talk. But if you're interested in this topic, do read this opinion. It's very interesting. So Representative Butler said of the Civil Rights Act of 1871, Section 8 is intended to enforce the well-known constitutional provision guaranteeing the right of a citizen to keep and bear arms, and provides that whoever shall take away by force or violence, or by threats or intimidation, the arms and weapons which any person may have for his defense shall be deemed guilty of larceny of the same. While discussing the 14th Amendment, Senator Pomeroy described as one of the 3 indispensable safeguards of liberty under the Constitution a man's right to bear arms for defense of himself and family in his homestead. These things are very unambiguous. It is clear that these people felt that people had an individual right to bear arms or that they ought to have an individual right to bear arms that is protected by the Constitution. So this is Jacob Howard, who introduced the Second Amendment in Congress, he wrote this rant that I really enjoy. He said, "These privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature. To these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution." Such as the freedom of speech and of the press, the right of the people to peaceably assemble and petition the government for a redress of grievances, a right appertaining to each and all of the people, a right to keep and bear arms, the right to be exempted from the quartering of soldiers in a house without consent of the owners, the right to be exempt from unreasonable searches and seizures, and from any search or seizure except by virtue of a warrant issued upon formal oath or affidavit, the right of an accused person to be informed of the nature of the accused accusation against him, and his right to be tried by an impartial jury of the lineage, and also the right to be secure against excessive bail and against cruel and unusual punishments. So I don't know. I wish that there were people in our Congress today who talked like this. Nobody does anymore. This is a very broad view of individual rights, and I wish that I lived in this country. The conception of the Fourth Amendment that's described here is the kind of thing that would make the NSA's blood boil. So it's clear that these people who created the 14th Amendment, who proposed it in Congress, they made numerous statements that seem to indicate that they felt that the right to bear arms was an individual right, and that the 14th Amendment incorporated it against the states. And so even if Madison didn't feel that way, the reality is that the 14th Amendment amended the Constitution, and there's a very strong argument that it was intended to amend the Constitution in such a way that states were required to uphold an individual right to bear arms. Now, what's the problem? Why didn't this happen? The reality is that these people were politicians, and they when they were in Congress, they talked a big game like this amongst other intellectuals of the time, but when they went back to talk to the people about ratifying the 14th Amendment, they downplayed its significance, and so there's an argument that the 14th Amendment shouldn't have these kinds of expansive consequences because the people who ratified it didn't necessarily understand that, even though the people who authored it did, there's this huge debate, which I referred to before, with respect to how the 14th Amendment incorporates the Bill of Rights against the states. There's this first section that says, no state shall make or enforce any law which shall abridge the privileges and immunities of the citizens of the United States. And then there's this other part that says, nor shall any state deprive any persons of life, liberty, or property without due process of law. The way that most of our rights have been incorporated against the states is through the due process clause. And there's a lot of intellectuals who think that the privileges and immunities clause is the right clause to use. And there's a huge debate about that between liberal and conservative justices. So, this process of actually, bringing the 14th Amendment's promise to bear has been a messy one, it has happened piecemeal, and it has happened over time, a lot of people didn't get the word initially. So this is another Tennessee Supreme Court ruling from 1871, and in this case they say the Constitution of the U.S. amendments are not restrictions on the states. So this was a couple of years after the ratification of the 14th Amendment. Clearly, these guys had still not gotten the memo. I think this ruling is interesting, though. It's referenced in Heller. And the reason it's interesting is because it kind of doubles down on and expands the lines that were drawn in Aymette, and basically by saying that there are arms of warfare, you have a right to possess them. The legislature can't prohibit that, but it can prohibit you from doing certain things with them, or annoying other people, or threatening other people with them, or taking them out of your grounds. There are other arms that have nothing to do with warfare, and the legislature can prohibit those completely. So that's the line that the Tennessee courts were drawing during this period of time. There's another interesting thing that happened. Actually before the Civil War, there was this case in Kentucky in 1822, and this was a very broad ruling from the Kentucky Supreme Court regarding the scope of the right to bear arms, and they invalidated a legislative act prohibiting concealed carry. Apparently, this ruling was very controversial. At least I've read that. Although it took like 25 years for Kentucky to amend their constitution to put the matter to rest. Eventually, they amended their state constitution, and they added this section saying the General Assembly may pass laws to prevent persons from carrying concealed arms. And so, again, clearly, Kentucky felt that they had the right to amend their constitution to say that, and there are a whole bunch of states that followed suit. So Tennessee did this in 1870, and again, I think it's interesting because Tennessee's constitution said citizens of the state have a right to keep and bear arms for their common defense. So common defense is a very general term. It doesn't seem to describe an individual right. But clearly, people by 1870 were thinking that it meant that there was an individual right, because they added this text saying that the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. They wanted to clarify that. And so if there was no individual right protected by the first part, then the second part would be unnecessary. But at the same, and it's also important to note that they did not empower the legislature to prevent you from keeping the arms at home. They just sort of empowered the legislature to regulate the wearing of arms. So it's what is not said sometimes is as important as what is said in trying to interpret some of these texts. A whole bunch of states ended up following suit over time, mostly in the period of time between the end of the Civil War and the beginning of the First World War. Frankly, there were a lot of people who fought in the Civil War who experienced sort of unimaginable violence and were very desensitized to that, and went all over the country after that with weapons. And we think of the Old West period after the Civil War as being very violent, and the reason is that a lot of people were desensitized to violence, and so it's not surprising to see a lot of states during that period of time attempting to contend with that problem, and they did so by amending their state constitutions to clarify that they had the right to regulate the concealed carry of weapons, or weapons in general. Now, what's interesting is that none of these states felt that the 14th Amendment precluded them from placing these restrictions on people's right to bear arms during this period of time. So I think that's noteworthy. Is that because they didn't understand the 14th Amendment, or is it because they felt that the 14th Amendment and the Second Amendment didn't interfere with what they were doing in regulating the carry of arms? That's a subject that is certainly debatable. So this is the big U.S. Supreme Court decision during the previous century, Miller versus U.S. in 1939. When I was a young man, this was the most recent Supreme Court ruling with respect to the Second Amendment. It might have been the only Supreme Court ruling. No, that's not true. There are older ones, but it was certainly the most recent one. In the absence of any evidence tending to show that the possession or use of a short-barreled shotgun at this time has some reasonable relationship to preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So they relied on the idea set forth in Aymette versus Tennessee, that some kinds of weapons you had a right to possess, and other kinds of weapons you didn't, and they basically argued that shot-off shotgun was not one of those kinds of weapons. So let's fast forward, to what just happened a few years ago in D.C. versus Heller. D.C. versus Heller was a case where somebody living in Washington, D.C. Sued because they wanted the D.C. government to recognize their right to possess a handgun in the home for self-defense purposes, and the Supreme Court ruled that they had such a right. The Second Amendment protects the individual right to possess firearms, and the city's total ban on handguns, as well as its requirement that firearms in the home be kept non-functional, even when necessary for self-defense, violated that right. Personally, I think that this ruling is essentially correct, although I probably don't have that view for exactly the same reasons that the majority does. Basically, my thesis is that Madison expected that the states would be able to constrain people's possession of arms, and so he wasn't concerned with federal regulation of arms. I believe that the 14th Amendment was intended to make the Second Amendment, an individual right, and it was intended to protect people's right to bear arms as individuals, and as such, I think that. That this sort of ruling makes sense, that the individual would have the right to bear arms in their home for self-defense. DC, the ruling in DC versus Heller, was very focused on the text of the Second Amendment, and basically they ruled that again, that the phrase in the beginning, a well-regulated militia necessary to the security of a free state, much as I stated, is just the reason for the amendment, and then the rest of the text actually explains what it does. And in my view, it was originally intended to just get the federal government out of the business of regulating arms. So the court placed a couple of caveats on their ruling. This is one of them. They said, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So, just as the First Amendment, has certain constraints, you cannot engage in slander or libel. You can't, engage in credit card fraud. Even though you might do it by speaking, the Second Amendment has constraints as well. There's certain reasonable or compelling state interests that governments can engage in that do not interfere with a person's individual right to possess arms, and governments can proceed in engaging those kinds of regulatory regimes. In addition, there was another caveat, and I think that this is probably one of the most challenging parts of the Heller ruling, and that is a traditional militia was formed from a pool of men bringing arms in common use at the time. Basically, the question is, can I have a machine gun at home? Can I have a nuclear weapon at home? Can I have a surface-to-surface missile at home? So the idea is, so they took a look at that idea, and basically they said that originally the militia was formed of people who had these weapons at home, for lawful uses, and they brought them to their militia service. And originally, the kinds of weapons that you had at home for hunting or for self-defense at home were perfectly adequate for militia service. It was the same kind of weapon. Today, that's not the case. Today, you'd need a different kind of weapon in order to be an effective fighting force versus the kind of weapon you might have at home for hunting or other lawful purposes. And so, the court looked at that, and they said two things. They said one thing really to the collective rights people, and one thing to the individual rights people. They turned to the collective rights people and they said this: the fact that the purpose of this right can no longer be served by the right, because technically this idea of a militia made of people who bring their weapons from home is obsolete. The fact that is obsolete does not mean that the right ceases to exist. If you want to eliminate this right, you have to amend the Constitution. So they said, so often people in the collective rights category just sort of say, well, that this is, things can't work that way anymore. Well, they said that's not sufficient to cause us to fail to continue to respect that right. On the other hand, they turned to people in the individual rights camp, and they said that on the same token, the fact that you would have to have a machine gun and maybe a surface-to-air missile in order to be an effective fighting force today does not mean that the right expands to encompass those kinds of weapons. And they pointed to numerous historical examples in which weapons that were considered to be particularly dangerous, had been prohibited, and those prohibitions had been upheld as not being a violation of the right to bear arms. And so, basically, they carved out this right to possess arms that would be, no more dangerous than the kinds of weapons you need for hunting or for self-defense in the home. I think that the way that they stated this is a little obtuse, and that has caused a lot of disagreement as a subsequent to this ruling. But let's talk about what has happened after Heller. Uh, so a lot of gun control regulations, particularly in urban areas, have been rolled back. Total handgun bans in Illinois, a ban on shooting ranges in downtown Chicago, total bans on concealed carry have been held to be unconstitutional. They have to have a concealed carry program. They can regulate it, but they have to have one. A ban on open carry in California was ruled unconstitutional. Um, a uh, so basically, a lot of the restrictions that used to exist on the possession or carry of arms, have been rolled back. But at the same time, some have still been upheld. The DC firearms registration requirements have been upheld. Also, the DC ban on assault weapons on high capacity magazines have been upheld. Uh, I think that there's no controversy really about the registration requirements. I think that clearly Heller stated that those kinds of restrictions are not unconstitutional. There is certainly a debate about particularly about what we call assault weapons. And whether assault weapons bans are or are not unconstitutional. I've seen different opinions from different scholars about this. Again, I think that part of the reason that this is controversial is because of the fact that the text of the Heller opinion regarding the subject is a little obtuse. He talks about common use, and there's different ways of estimating common use, and so you see people engaging in these arguments about the numbers of these weapons, and there's this circular argument involving how many of these weapons would be in people's hands if they weren't already prohibited by law. And then, so there's a set of disagreements there. There are a number of law professors who believe that those kinds of bans are not unconstitutional. It remains to be seen if one precedent in D.C. is not enough to establish a trend. There's probably going to continue to be some arguing about that over the next few years, but it remains to be seen where we're going to end up on that. I think that depending upon your perspective about guns and about gun rights, you can look at the current situation and you can either feel that the glass is half empty or you can feel that it's half full. People who have a collective rights point of view are obviously very frustrated about Heller. They've seen their point of view torn down. I honestly think, although there is support in the historical record for the collective rights view, there's also plenty of support in the historical record for the individual rights view as well. And so I don't think it's obvious that the Second Amendment is simply a collective right. But at this, and then people who are individual rights advocates, they often don't like registration regimes. They're very concerned with the ability to possess what we call assault weapons. And so the fact that those bans are still being considered to be constitutional, they may also be frustrated by that. And so people on both sides of the spectrum may look at this ruling and say, this is a negative thing for me. I disagree with this. This is not what I want. However, I think that it is possible to have a positive perspective on what has happened, regardless of what camp you're in. So if you are an advocate of the individual right to bear arms, the fact is that a lot of the restraints that existed on your ability to exercise your right to bear arms have been rolled back over the past few years as a consequence of Heller. You can do a lot of things that you couldn't do before. And furthermore, what's really important is that the Supreme Court has put a stake in the ground and said that you do in fact have an individual right, and that individual right is going to be protected. And I think honestly, it's very unlikely that conclusion is going to be overturned at any point in the future. And so, what has been a debate for a long period of time, I think, has largely been settled in your favor. And so you can feel confident about that. And at the same time, if you are someone who's interested or concerned about the impact of guns in society, the reality is that even though you sort of lost your legal argument, um, a lot of the resistance that gun owners have to things like registration regimes is a fear that that will lead to confiscation. And that ultimately, if they give you an inch, that you're going to take a mile. And many of you know that you do intend to take that mile. It's not a simple matter of them being paranoid. And so now that their right to possess a weapon, has been clearly demarcated by the court, they may be less reticent to give you your inch because ultimately you can't take the mile even if you want to. And so, there may be less resistance over time as people become more confident in the holding of Heller to things like registration regimes because they don't believe that ultimately those things can result in confiscation. They believe that the government does respect and will uphold their individual rights in the end. And so ultimately what that may mean is that it's an opportunity for people who are concerned about gun violence to create regulatory regimes that don't interfere with people's individual rights, but that are effective, and to do so with less resistance than they've received in the past. I think that it's a glass half empty or half full proposition. I tend to think the glass is half full. I'm glad that the court has concluded that there is an individual right here. I do think it's reasonable that some kinds of regulations can exist within the context of that individual right. I think that it creates a platform for us to have hopefully a more healthy dialogue about this in the future. I don't think we're there yet. I think Americans are still very divided on this issue. I personally think that Heller, is a ruling that may take us in a direction of greater sanity going forward. So that's my point of view, and I hope you found this interesting and worth an hour of your time.